The Cole Memo is brought to you by listeners like you. One of the best ways to support my work is absolutely free. Subscribe to the podcast on your preferred platform, leave a positive rating, smash that like button, as the kids say, and share it with your friends. Your engagement helps make the show more visible to others and supports the mission. If you'd like to support the show financially, consider becoming a patron at colememo.com/Patreon for exclusive access to new episodes as they release. Big shout out to my patrons. Thank you. You're listening to this episode first. If you're listening right now, you can also make a direct contribution at colememo.com/support, which I'm displaying on my screen right now. You can make a one-time monthly or yearly contribution of your choice. That's right. You can pick, $5, or if you just want to donate $2, you can do that. And all of your support is appreciated. Thank you. Enjoy this episode of The Cole Memo. Today is November 19th, 2024, which is hard to believe. The year is just flying by. Welcome to another episode of The Cole Memo. I'm Cole, and if you didn't know why the show is called The Cole Memo, I'm displaying a graphic right now. You can also just Google it, and it'll make sense. It's not just because my name is Cole. Today I'm joined by my friend Allie. Allie, welcome back to The Cole Memo. How's it going?
Thank you. Good. Thanks for having me.
Yeah, and could you please reintroduce yourself? You've been on in the past, like I just said, but for folks that may not know you, please introduce yourself.
No problem. I'm Allie Jubileer. I'm an attorney. I work for a law firm called Benish now. Started there in January in the cannabis practice group there. And prior to that, I have a somewhat winding road of a career. I started at a law firm like most lawyers. Then I was in-house at Tribune for many years, then Groupon for 7.5 years. And then I'd like to say I made the leap to the dark side in 2019 and became the general counsel at Revolution here in Chicago. Was there for a couple of years, then did about a year-long stint with AeroPay, helping them with legal needs and HR. Then I decided to start my own cannabis company in New Mexico. So that was my 2.5 year detour. Continued to practice law on the side, my background being employment law prior to cannabis. And then find myself practicing law full time again, starting in January. The business didn't go as I'd hoped, but I learned a lot and still have some side hustles up my sleeve.
Yeah. Well, I would ask you, how do you keep it all together with that, wide-ranging list of things that you do? But I know the answer. It's cannabis. I'm just joking.
It's true. Lots of cannabis. No, no, but I do. I'm passionate about it. I'm passionate about the subject of it and
Sure.
learning about it, and I find it fascinating. I mean, the ground is moving beneath us every single day. State law, federal law, hemp, cannabis. You name it. So there's never a dull moment, and it really is. I mean, as you know, because you're in it too. It's a fascinating area to play in.
Yeah. Speaking of which, I recently saw a headline that grabbed my attention. To your point of things are just, every day there's something new. The headline that I'm reading, and I'll have this article in the show notes for people that would like to read it for themselves. It's from the Chicago Sun-Times. The headline is Illinois cannabis transport license process discriminates against minority-owned businesses, lawsuit says. Allie, would you be able to tell us a little bit about this lawsuit, perhaps?
Yes, I can. um, so I have spearheaded this lawsuit, and I started working on it not long after I started at Benish, so probably like February or March. Um, the case came to us through mutual connections who were working with Illinois transporters and had seen what they had gone through, and they were trying to find a law firm that would consider taking them on a pro bono basis to try to remedy some of the things that had happened to them. And there had been some past attempts, sort of, at this, but when I took a look at what had happened to them and I looked at the data, my employment law brain kicked into gear. And I started analogizing what had happened to them to what we call a disparate impact claim in employment law, where you have a neutral policy that has a disproportionate and negative impact on a particular protected group as compared to other groups. And that's what really jumped out at me was that you have the independent transporters who only have transporter licenses and who are largely minority and women, and who have pretty much been decimated, and unable to have really any kind of stable business in the last few years. And then you compare those to, for example, the medical cultivation centers that received their transporter licenses, who, were not part of any social equity program and therefore are not a diverse group. So you're comparing, essentially the non diverse group to the diverse group of transporters, of independent transporters, and you're seeing that one group has been disproportionately impacted. And that is how employment cases work. And so I started doing some digging and researching and came upon the Illinois Civil Rights Act, which is analogous to a disparate impact employment claim, except that it's not in an employment context. So the law basically requires state agencies to administer their processes without regard to race, and to not use criteria and methods of administration that result in discrimination. And so that was the statute that I started to explore and realized that we had a case and started putting it together.
Gotcha. Gotcha. And, I know that you have a presentation prepared today. Do you want to jump right into that, or where
Yeah,
should we
sure.
begin?
We can put that on there. It's
Sure.
a good guidepost for the case because it is a little confusing. Words like disparate impact
Yeah.
don't
And
necessarily mean much to people that
while
aren't
you're
lawyers.
pulling that up, I mentioned earlier that the uh, Chicago Sun-Times article would be in the show notes. Also, folks, if you're listening and you would like to watch this so that you can see this presentation, that link will also be in the show notes. So you can always find the video version of this podcast episode. So, really excited. Thank you, by the way, for taking the time to come on and share this with my audience. I've been reading about this, but there's nothing like getting firsthand knowledge.
Uh,
So,
I appreciate the opportunity, honestly, just to shine a light on the case. And there's a veto session coming up in November. And so this just helps people remember that the independent transporters are still out there and still struggling and still need help. So, yeah, I just put together this little presentation. And Cole, you were saying that people watching the podcast can see this separately, right?
Yeah, and I can't see it yet, so I'm not sure if you've activated your share just yet. Yep, I can see it, so you are good to go.
As I was saying, I just put this little slide together. It's an overview of the case. The one thing that sort of bolsters what I was saying earlier is that there was this disparity study that came out in July of 2024, which found, quote, observed disparities with respect to the transporters, suggesting potential discrimination. At the time, there weren't any transporters that were actually active. So it was difficult to assess, I guess, the discriminatory impact. But you can see that despite that, in the disparity study, they made recommendations for how to help the transporters. They underscored the challenges that they were facing that seemed to be aligning along racial and gender lines, and navigating all these complex regulatory frameworks. And so the disparity study really highlighted very clearly, kind of what was going on with the transporters. And for us, as the people running the case, that formed the basis for the data, that we were looking at. And then we kind of updated the data from there with our own information. But the main, the thing that I think stands out the most is that last bullet, which is that after 4 years, there's only two active minority and or women owned independent transporters in the entire state, and they're hanging on barely.
Wow.
So yeah, it's pretty damning. Just the numbers themselves are pretty damning.
even the fact, to add to your point, and I don't know exactly how how to add anything past this, but maybe you can. The fact that there's only 55, this is one of the only license types that there were an unlimited number for. So the fact that it even whittled down to 55 says a lot in and of itself,
Yeah. Now,
right?
55, those are the minority and women owned. So the total number of independent transporters in the state is 80.
Oh, okay. Thank you for
Yeah.
clarifying.
Yeah.
Gotcha.
And those are only the independents. I believe if you go on the IDOA website, like today, it'll show you 163 transporters total,
Mm,
but that includes people who have multiple licenses.
gotcha.
And so these folks only got the transporter license. And you know, that 55 of them are minority and or women owned means that the vast majority of independent transporters are minority and women owned. It's 68.8%, which is about the same as the percentage in the disparity study that came out in July 24.
Gotcha.
So yeah, so it's pretty sad, for a social equity program to have that kind of stat.
Right.
Um, so again, just kind of going back to like where we came up with the case, I come from an employment background. I spent over 20 years practicing employment law and only employment law for law firms and for companies. And so I often come at things from that angle, like just having my brain looking at those things for so many years. And as I mentioned, it was the disparate impact concept in employment cases that kind of inspired this. And the example I always give as to what disparate impact discrimination is, because a lot of people don't know, um, is a firehouse, using a firehouse example. So back in the day, you would have a firehouse, and the requirement to become a fireman at the firehouse was that you had to, let's just say, be able to lift 300 pounds in addition to all the other qualifications. And on its face, a 300-pound lifting requirement seems neutral, right? But what was happening was that women were not able to lift that kind of weight. And so they were saying we're being prevented from joining the firehouse because of our gender related to this criteria that you put in place. So then the burden switches back to the firehouse to say, okay, well, the heaviest thing that a fireman must lift is the hose, and it's 150 pounds, right? Well, so then the burden, then the argument, if that's the argument, then that means there's not a good business justification, right, for their 300-pound lifting requirement. And the impact of that 300-pound lifting requirement is that women cannot be part of the firehouse. So the court would strike that down as disparate impact discrimination. And they would say that neutral 300-pound policy has a disproportionate and adverse impact on women, preventing them from becoming, members of the firehouse, and therefore it violates Title VII of the Civil Rights Act. So that's all in an employment context. So then you apply that same theory to this, and what you're looking at is you're saying, okay, where are these neutral policies and practices, some seemingly neutral, right? Practices and policies that the IDOA is putting forth with respect to licensing and operationalizing independent transporters. And are those processes, discriminatory? Are they, despite being neutral, impacting a minority group? And in this case, that's what we saw. So that was kind of how I came up with this whole theory. Um, the only other case that has happened was the Pterodon Solutions case that another law firm filed a few years ago against the IDOA with respect to asking the IDOA basically to enforce their rules with respect to transport regulations. Um, that case was brought by Greenspoon Martyr, another firm that does a lot of cannabis work. But in that case, it wasn't, they weren't making an allegation like I was under the Illinois Civil Rights Act. And they were only asking for the court basically to declare that the IDOA wasn't doing its job and needed to enforce its rules. And the case was ultimately dismissed because the IDOA really has maximum discretion to figure out when they're going to enforce their rules. So it's kind of, I guess this is my long way of saying somebody kind of took a stab at doing something on behalf of the independent transporters, but it didn't get very far. But I do think that this case has legitimate legs based on the data and the statute and, the timeline, essentially.
Yeah.
Um, and so that was one of the reasons. So once I had the opportunity to, pursue it, I was really excited because, I had hung my own shingle for a long time when I was running my own business. And when you're doing that, you can't do, it's nearly impossible to take on pro bono work, which is free legal work for other people. But because I'm now at a firm, at a really great firm that values pro bono work, that cares about giving back, and that is willing to let me spend, their money essentially on a pro bono case, I'm just really grateful because I couldn't have done that before. So, like I said, I've been working on this for almost since like February or March, so it's been a long time, a lot of hours. But I'm
Yeah.
really grateful that the firm let me do it.
Yeah. It's awesome that, yeah, like you say, you're able to do that because you can't do that pro bono forever.
Yeah, and it's really special to do something that's a pro bono case in my own field. Like I've done other pro bono work, whether it's I don't know, I've done voting protection, I've done pro-choice kind of work. I've done other, cases and things for other kinds of pro bono plaintiffs, but I've never done a full pro bono case like in my field. And so it feels cool to do it and give back, especially because in my view, if you're on the totem pole of licensees, the transporters are at the bottom of that totem pole, and I think probably have, over time the least amount of representation and advocacy.
Yeah.
So I'm happy to be able to do that for them. So this was just another slide about a case study called the Chicago Urban League versus the Illinois Board of Education. And this was also what inspired me to pursue the case. So I had this idea in my head of like this analogous disparate impact employment claim. But then I was like, okay, well, now I need to find an actual statute, right, that provides that same kind of analysis and relief. And so that was the Illinois Civil Rights Act. And then I went and looked at cases, and I found this case from the Urban League where they sued the Illinois Board of Education because they said that the way that the funding process was happening was adversely impacting minority kids in terms of how the funding was getting divvied up amongst kids in the state. And the case made it past a motion to dismiss by the Illinois Department of Education. Um, and the court found that there was a basis for Urban League to pursue these claims. I believe the case went on for something like 7 or 8 years and ultimately settled. But the similarities are, totally different, right? Like Board of Education versus the Illinois Department of Agriculture, but conceptually the same thing, right? Like this process that they put into place that had a detrimental impact on on a particular group, even if it was unintentional. And so this was part of the inspiration for the case. This is just more information about it, that the court held the plaintiffs met their burden um, to allege facts demonstrating that minority students suffered injury from the discriminatory, albeit unintentional, effect of the implementation of the funding system. And so that's again very similar to what we're alleging, that our plaintiffs have alleged facts demonstrating that they have suffered injury from the discriminatory, albeit potentially unintentional, effect of the implementation of the CRTA with respect to independent transporters.
Gotcha.
So here's just some of the data that I thought would be interesting to show. So this is cool. What I was saying at the beginning, there's been 100 on the IDOA website. It says that there's currently 163 total licensed transporters, but that would include like craft grows who have transporter licenses and infusers and stuff like that. So then of that 163, you've got about half that are independent, meaning they have no other licenses. And when they did this solely to be a transporter of cannabis in the state of Illinois. Out of that 80, then you've got 55 that are majority minority and women owned. So that's about 68.8%. And then out of that number, you've got two active, which is Piff Patch and Hands to Heart.
And my apologies just because you threw a lot of data at me.
Yeah, sorry.
No, it's okay. It's good. This is perfect. What does that number include the originally established licensees, like from the medical program, is my question. Or are we going to
Um,
get to that?
we're going to get to that. No, this
Okay.
does not include the MCCs. So this is
Okay.
strictly people that applied under, that applied mostly as social equity applicants
Yeah.
under the
Does
CRTA,
MCC stand for Medical Compassion
Cultivation
Cultivation Center?
Center.
Okay, thank
Sorry
you.
about that.
No,
Yeah.
it's okay. It's good. I'm breaking it down for the audience. It's
No,
okay.
I appreciate it. I should
That's
have
me
sometimes I've
pretending like I knew what you were talking
well,
about.
I just throw out acronyms all the time too, and
It's
sometimes
okay.
forget that I need to like explain what it means. So
No, it's okay.
sorry. Yeah. So the medical cultivation centers were the original 21
Yep.
that got the very first licenses under the medical only Compassionate Use Act.
Yep.
So, and it's a little bit complicated, but transport was part of that when they were licensed initially.
Right.
But then you had the adult use CRTA,
Hmm.
and that put in some restrictions around the MCC ability to transport through certain dates. Um, and ultimately, they were required to get transport licenses. The MCCs were also required to get official transport licenses from the IDOA in order to safely and compliantly transport their cannabis. But as I'll describe, it turned out to be kind of two different processes, even though it all happened under the CRTA.
Yeah. Cool.
So this is kind of what you were getting at, Cole. So here's the medical cultivation centers, the MCCs. This has they have 22 because there are, I think, according to the IDOA now 22, even though there were 21
Right. I can
initially.
give a little bit of
Yeah,
background on
you
that.
probably know more
So
about that
there,
than I do.
yeah, it's based on the number of state police districts in the state, but apparently the
Mm.
22nd district is a tollway. So like nobody lives there. You
Mm.
can't give a license for that. So there's only
Okay.
21.
Got it. All right. Well, I stand corrected. It's some places you'll see 21, some you'll see 22, but
Well, I think that the number is 22. It's just that they won't. Anyways, sorry.
yeah,
We'll
no, it's fine. We'll flesh it out in litigation. That's what
yeah.
it's for. But
There
the
you go.
point I the point is, all the MCCs were not part of the social equity program, right? Social equity was not part of the original medical, licensees and the Compassionate Use Act. That didn't come into play until the CRTA. So you've got 21 or 22 of these guys, right? And then they're all actively using their transporter licenses to our knowledge, and none of them are minority and or women owned.
Right.
Then you've got your independent transporters who are 68.8% minority and or women majority owned. And you've got 80 total independent transporters, and you've got, well, and 55 of those being minority and women owned, and then you've got two that are active. So you're really, when we're comparing for the case, what we were looking at is the active status of the transportation licenses and comparing, right, the independent transporters to the MCCs. And the MCCs are all active and the independent transporters are mostly not. So that's kind of like the real, sort of breakdown, and why the racial, the minority, and protected category piece of it is so compelling, because you look at these numbers and you've got, one group that is diverse and failing, and then you've got another group that's not, that's doing, I would just fine, I guess I would say. Although I'm sure a lot of the bigger companies would beg to differ with the just fine, characterization, but you get my point
Yeah.
for
No,
purposes of the case.
right.
Yeah.
They're
Um,
transporting. How about that?
yeah, right.
So,
Um, so and then just timeline, this kind of lays out all the timing. And I think um there's a lot of stuff that happened in here with COVID, and there were executive orders and delays. But the thing that really stands out is that ultimately, the IDOA issued the MCC transporter licenses before the independent transporter licenses. And when you think about what these people went through to get their licenses, and the fact that there's was like no market for them, and then on top of it, just the timing just looks pretty bad. Um, and then, of course, it took most of them well over a year to become operational. So even though they got their licenses in August, they had to go through over a year of back and forth with the IDOA to get the green light to become fully operational.
Right. Well, and then even we don't have to get into this so much, but even when they are operational, quote unquote, it's like, was there even product at that time to transport? And, uh, you know, it's
Yeah,
becoming more and more of a thing nowadays as the craft cultivators become, they go
right.
online. But back then, that was not the
Right.
case.
Well, and that's why the MCCs, the medical cultivation centers, is that's why they're the focus of the comparison because they were the only other ones that had transport licenses at the time
Right. And
to
product
compare
to
to
transport. Yeah.
and product to transport. Exactly.
Yeah.
Um, so yeah, so it's just a pretty nasty like picture and timeline when you look at it all and you realize that by the time these people got up and running, it was the end of 22.
Yeah.
Um, and in that time, the MCCs were transporting their own cannabis, and the IDOA was putting them through the hoops and to get operational.
Yeah. And I realize I jumped the gun by one slide last time, but I have to ask this question while it's on my head, just because
Hmm.
I figure it's a quick yes or no. Will the comparison that you referenced on April 30th, I wanted to highlight that for people. The idea that, this is what stood out to me about the case, was there was this idea of a quickie application, and then there
Hmm.
was like the application for everybody else. Will
Yeah.
we be talking more about that? Am I jumping the
Yeah,
gun?
yeah, I
Okay,
kind of
sorry.
glazed right over that, but yes, yes, and the problem with that is that those exhibits and plans that are submitted with your application are binding, like into perpetuity.
Yeah.
So if you submit 15 exhibits, you're bound to 15 exhibits. If you submit two, you're bound to two. And so that by setting up this shorter application for the MCCs, the IDOA really created a disparity in the compliance obligations of the MCCs versus the independent transporters.
And that's something I think that we should explain it just briefly, is like when you're saying bound to, like, so with
What
these
does that mean?
15, right? And I'm guessing it's like for 15 exhibits, it was like probably like questions like, how are you going to deal with this? And you're basically outlining what your protocols are going to be. And am I correct by saying
Exactly.
when you say you're bound to it, it's like they made these protocols in 2020, 2019, maybe 2018. I don't know. Like
Correct.
before any of COVID happened and everything, they obviously nobody can tell the future, but you're saying they're bound by those things. They have to abide by all those protocols that they
Yes.
wrote all
And it's not
these.
just the transporters, it's everybody,
Sure, but
and
then I was going to take that the layer deeper, is that you're saying they had 15 and the MCCs only had two.
yes. Yeah.
Wow. See,
Now,
that's
I don't want to make the IDOA's argument for them, but I'm sure they will say that because the MCCs were already licensed and had been growing and
sure.
manufacturing and transporting for years, that they didn't need to submit the same level of information, right, that the independent transporters did. And that may be well and true and good, but by doing it this way, by only having, by having this huge disparity in the number of exhibits that they were required to submit, um, they set up this disparity in compliance obligations that really can't stand, in my view. Um, they should have just had, I mean, they should have just had the MCCs complete the same application as the transporters, right? And then all the compliance obligations would be the same. But by doing it this way, they made it, they created this disparity and they also, caused the transporters to spend a lot more money than they probably needed to spend, to do what they to get licensed.
Gotcha. Gotcha.
Yeah. So I didn't mean to gloss over that. That is the compliance piece is a big deal. One of the biggest deals, I think. And, we'll find out more in litigation, but all these the problem with all this information is that the IDOA took so much time, you know, a year and a half to to hold these transporters to all these exhibits and plans that they put forth. And to your point, their security plans where they make commitments to certain security companies and software. There's vehicles that they identify that they're going to use, the security that they use for the vehicles, the security inside the vehicles for transporting the cannabis. They have to have a business plan. They have to have, diversity plans, employment plans. I mean, all kinds of stuff. It's outlined in the complaint, all the things that they had to submit. And I think as a result of how the IDOA administered the application and the exhibits, it took a really long time for them to become operational, and it wasn't necessary to do it the way they did it. And they should have held the MCCs to the same obligations.
Yeah, and can we get into more about the just, I don't feel like there's a lot to talk about, but one thing I didn't know about was the executive order. When I read about this in the
Hmm.
reporting, I was like, hindsight is 2020, but can you
Yeah.
talk about that?
Yeah, I mean, basically, right when COVID happened, Pritzker came out with these proclamations, and executive orders where, for example, he declared, I think that, dispensaries were, uh, what was the word during COVID? Required,
Essential.
essential. Thank
I'll
you.
never forget that.
And could
Yep.
stay open. Yes.
That was
And
cool.
that was good. And then, but he also, again, it's COVID, but he put out, an executive order that basically delayed the issuance of applications and delayed the IDOA's administration of those applications, gave them more time, essentially. So that was just part of the history, sort of everything that happened. But after the end of that was when the IDOA issued, after the executive orders had ended and we were rolling into, this was the summer of 2021, they finally issued the MCCs their own transporter licenses because they needed them to compliantly transport.
Gotcha.
Yeah. It was just one more, you know, delay in this whole process that people had to deal with.
Yeah, that's crazy.
Um, So this slide I just put together about the Illinois Civil Rights Act. This is the basis. This is the one of the statutes that we cite to in our case. And again, without kind of reading the whole thing, essentially the statute says that no unit of government in Illinois can engage in practices that discriminate against people, and it allows a private right of action, a lawsuit against any agency to hold them accountable for the discrimination and disparate impact. Um, and uh, what was interesting about this is also um, that states generally have immunity from being sued, including Illinois. So, for example, in that Urban League case I mentioned earlier, they sued the state of Illinois and they sued the Illinois Department or the Illinois Board of Education. But the state of Illinois got tossed from the case because they have immunity from being sued. And so in this instance, the statute limits it to units of the government. And so that's why we sued the IDOA.
Gotcha. That makes sense.
Yeah. And this is just the statute itself and the actual language, if anybody wanted to see it. But and there's two parts to the statute. The first one is that no unit of the state government can exclude somebody based on their race or their gender or national origin. And that would be what I would call more of a direct discrimination claim, where you're saying somebody made this decision based on race. And then the second part of the statute, the utilizing criteria or methods of administration, is more of the disparate impact claim that I was talking about. So basically, using criteria or methods of administration that on their face don't seem to be discriminatory, but that have the effect of harming a particular protected group. And so this statute allows us to bring a civil lawsuit. The plaintiffs can be awarded actual damages, and the court can grant any other relief that it deems necessary. So this was the basis for that Urban League case as well. for one of
Gotcha.
the statutes. Um, and so this dives a little bit more into what you were talking about before with the transporter application, the shorter, cheaper, quickie application that the IDOA created for the MCCs that we talked about earlier, that had, only 2 exhibits versus the 15 exhibits that the independent transporters had, um, and which created different compliance requirements for the two groups, one of which is majority, minority, and women owned, one of which is not. So these are kind of like, these are just quick bullet points that, kind of pulled from the case about some of the things that the IDOA did where they had discretion and could have chosen a different path or a different decision and um, you know, instead did what they did. So like storage, for example, right? The independent transporters are not allowed to store
Right.
in between transports. But the word storage doesn't even exist in the CRTA. It's not even contemplated in the
And
CRTA.
that is crazy so what you're saying is I want to make sure we give background on this, but what you're saying is that IDOA could have chosen hypothetically
Hmm.
to allow storage because again,
Hmm.
storage is not in the
Hmm.
CRTA, but you're
Hmm.
saying they didn't do that because there's a
Because they're
prohibition on storage.
right. Well, it's not a prohibition on storage. It's just that the statute says you can transport from, you know, the cultivation to the dispensary.
Right.
And
Okay.
so they're, I think, viewing, so they're saying transporting cannabis to a storage location before you get to the final location is also transporting. And because the statute doesn't say explicitly that you can do that, you cannot.
Right. And for background, the reason this is important is because Illinois is a big state. Can you take it from there?
Yes, it is a very big state. Transporting often is about logistics and making sure that you're combining, orders to all go, for example, downstate at one time. So you're not going back and forth and making these really long trips. And it just allows the transporters to be, more efficient with their time. It also, I've heard some people say that it could be considered almost like a safety issue too, because if they don't have the opportunity to store, maybe they're on the road for too long and they're tired or things like that.
Yeah.
Um, but ultimately, it's just one more thing that makes it hard for them to be active and successful companies because they can't do something that all the other multi-licensed licensees that have transporter licenses can do.
Well, even I've even talked, not to take us on too much of a tangent, but I've talked to some of the MCCs that are, let's say, not ideally located to serve the entire state. So they may be at one extreme or the other. And you have to realize I was actually just about to pull it up. Like I was trying to figure out like how long it takes to go from
Yeah.
Southern Illinois to Chicago. I think it's about like 6 hours.
Yeah, it's a long
So you
time.
figure you have to the element maybe we haven't touched on, or maybe you did, and I just want to make sure we did though,
Hmm.
um, is that it's got to be back by a certain time, which is really the or delivered by a certain time. Like it can't, you know what I mean? I guess that's what I've heard from the MCCs is that when they have to travel north, to your point about logistics, they make sure that that day that they can get their behinds back in
Right.
time because
Right.
they can't afford any like, oh, the inventory wasn't right or whatever,
Right.
and then they have to
Right.
take it back. Like they can't literally can't do that in one day.
Yeah. 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 I mean, it's just, and if they have dispensary licenses or infuser licenses or, um, if you have a craft grow licensee, they can store because they can store the
Oh,
product on their other license.
interesting.
Yeah. But these guys can't. And so it's just one more like, negative to using an independent transporter. And it just, what I would say is that when there was ambiguity or when there is ambiguity in the CRTA and the IDOA could have made a more equitable decision with respect to the independent transporters, they always seem to choose the less equitable position.
Yeah.
And, um, I can't exactly speak to why that is, but I don't know why you would look at that's the CRTA, that statute, see that it was silent as to this concept of storage in between transports and not try to make that happen for your independent transporters who are desperately struggling.
Yeah.
And I'm not even sure it would move the needle all that much at this point, but at the beginning, certainly it was, maybe it would. And at the beginning, it was certainly something that was like another negative towards using an independent contractor that they can't, I mean, independent transporter that they can't store.
Mm,
So,
interesting.
yeah. So the storage thing, there's a biotrack issue that prevents independent transporter new hires from starting right away. Without an IDOA issued agent card. And that seems to be something that is fixable within BioTrack, but has not been fixed. And so that's another thing that harms them, and another way that the IDOA could use its discretion to make things better for the transporters. Um, and then, just like I said, general inequitable enforcement of the rules, delaying their ability to get up and running for over a year. I mean, why? You know,
Yeah.
Like that's my big question is why? Why did you do this to these people? Like what
When, and especially when given the flexibility, it's one thing like, and we will not get into this, but like I have like, there are things that I do not like about the CRTA, but it is what it
totally
is, and they have
right.
to enforce it the way that it
Exactly.
is.
Right.
You know what I
And that's
mean?
why we were really focused in this case on like what are the things, like you're right, the law says what it says, right? And so they
Hmm.
have to act within the law. But when you look at these things, and there'll probably be additional things that come out during the course of the litigation, I'm sure there will be, but when you look at these places where they had the opportunity to do something more equitable, they just always seem to choose the other path. Um,
Yeah.
and the CRTA requires that they act in an equitable way and with the least amount of burden, to the applicants. So it just seems like antithetical to their mission to keep, these minority and women owned majority businesses like down like this, you know,
Yeah.
when they could have done something different.
Yeah.
So, um, and then I think this might be the last slide, but this is just, under the statute, the kind of relief that we can request. So one of the things that we talked about earlier on with the case is that, you know, and also based on past unsuccessful attempts to have a court like intervene and make the IDOA do something, we decided that wasn't what we are not, this case is not about changing the legislation or changing the rules. That's for the legislators to do. And if we can shine a light on the transporters and help them to help get rules in place that are going to be better for them, great. But really, our case is focused on past damages, right? So it's like for all these people that were sold this golden ticket that turned out to not be a golden ticket, right? Like our position is that they're entitled to damages for the money that they spent to try to get this business up and running. Um, and people emptied out 401ks and used personal funds. Lots of people are paying personal funds now just to keep their license active. Um, but there's been, hardly any revenue to speak of. And I just, like any generic piece of litigation, they got sold something and it was a lemon, and now they're entitled to damages for it. At least that's our perspective.
Yeah.
um, and you can see, I actually wanted to look this up. I didn't get a chance, but you can see that like, this number is what this was the total revenue that the IDOA earned from independent transporters um, for 2023, I believe that was. I'd be curious what it was for 22 and 21. I haven't looked. And that would include multi-licensees too, not just independent transporters.
Yeah. That's interesting what they're, go ahead.
Oh, no, sorry. I didn't mean to do that. Just what they're reporting. Yeah.
I was just saying it was I think you went but yeah, there you go. I thought it was just interesting what they are requesting and what they aren't requesting, you know.
Yeah, well, and when I say they in here, I mean the plaintiffs in our case,
Right,
but like
right.
what we, so I guess we really, but what we are requesting is all that, the application fees that they send, the licensing fees, the renewal fees, compliance related fees and fines, costs for them to start operation, like purchasing their vehicle and outfitting the vehicle to be a cannabis transport vehicle with upgrades and security and equipment. And I mean, these people spend so much money on this stuff. Some of them have, offices and rent that they pay too, even though they can't store there. And for what? You
Right.
know, for what? Um, and I don't know what will happen, I mean, they may not get any relief ever from the legislature. Which is why I think it's important to at least get them, if possible, damages for what they've spent and how they've been harmed to date.
And that's what I guess I was asking. Like I had a hard it's hard to put that into words, but it's like they're just they you did some math and you have other figures that you can reference. I guess my point is it's not like you're like we each need $1 billion
No.
like you know like
No, no, these are
yeah,
actual, actual damages. And there is the possibility to ask for future damages too for money that,
sure.
they were
Right.
it, believed that they would have coming to them from their business. But yeah, we're not, this isn't like we're not asking for punitive damages or like anything like that. This is strictly like these people were harmed and someone needs to do right by them,
Yeah.
and there's a basis for it. An actual, an actual statute that fits what happened to them and that can be applied to get them damages. So that's the hope. Um, oh, this was just a quote that I had. I don't know why I put it in here, but I didn't know that much about the transporters when I didn't know about their plight, if you will, when I started this. But um, when you put the whole thing on paper, what they went through was pretty bad. And um, and then when you look at it along racial lines, it looks even worse. So we do feel we have a strong case under the Illinois Civil Rights Act. And I think what will be interesting, Cole, is to see if other people follow suit after this case. Like if we survive, we anticipate that the IDOA will file, a motion to dismiss. Um, and hopefully we'll survive that motion to dismiss. And if we do, I wouldn't be surprised to see others um, making a similar argument under similar laws. And we've seen it already. There was a New York case that came out. They actually just sued the New York regulators, small cannabis, um, small farming cannabis organization, pro bono organization that just sued the OCM in New York for their rollout. But again, it's interesting because they asked for the same relief as that other case I mentioned, the Greenspoon case. So they
Mm.
asked for like a declaratory judgment and injunctive relief. And I'm not sure that's going to be a successful um, strategy, but maybe I'll be wrong. What's different about ours is we're not asking the court to, we're not really asking the court for injunctive relief. We're just asking the court for damages. And ours is very like data intensive. Like you can look at the numbers and they kind of speak for themselves. Like the dates are what they are, the numbers of people that got licensed are what they are, the number of active transporters are what they are. You know what I mean? So it is a very like data driven um, case. And then it's a question of looking at the criteria and methods of administration that the IDOA used. And to your point, like where they were boxed in by the law and then where they had discretion and then what they did when they did have discretion.
Yeah. Yeah. So it's
So it's an
interesting.
interesting theory, I guess, and different from other theories I've seen in the space.
Sure. Sure. Well, this case has caught, definitely a media wave, if you will. I've seen it reported by a lot of different outlets. What are the next steps?
Hmm.
Like, when do you go to court, for
Yeah, I
example?
know. Well, I think, like I said, what's going to happen is that
They're going to request that
Well,
injunction or something.
they'll file what's called a motion to dismiss,
Oh,
and they will try to get the case thrown out of court based on a lack of a basis for a claim. They'll throw some other stuff in there too, I'm sure, but that will be the next step. And so that will then result in pleadings being filed back and forth. So they'll file their motion in a whole big memo, which you'll be able to see because it'll be public, about all the reasons why our case is garbage and needs to be tossed. And then we will file a response about all the reasons why our case is not garbage and why it should not be tossed. At this stage in the litigation, the court is supposed to look at the pleadings on there and accept everything as true in the complaint, and then accepting everything as true, decide whether it should be tossed. Does that make sense? In other words, if you believe everything in the complaint is true, is there a basis for it to move forward?
mm,
And that's the standard that the judges look at the complaints, because at that point we haven't done discovery, we haven't traded information
right.
with the other party, right? So we put together a good faith complaint based on the research and data that we did, and the court has to take the complaint on its face and then decide on its face, did we make a good enough case to keep going? And so the hope is that we do. I'm confident that we do have enough to keep going. So we're ready for their motion and we'll file our response. And then if the court agrees with us, then the case will proceed into what's called the discovery phase, where we trade information back and forth. Maybe there's depositions and things like that. And then it'll keep going from there.
Interesting.
Yeah.
Interesting. Yeah.
Yeah.
Whatever, wherever it is, whenever it is, I just hope it's live streamed. I always think it's cool when they live stream court, you know? Did they do that in Illinois?
um, remember. I don't think they do. I mean, I've seen it in Florida. I watched
Right.
arguments in front of the Florida Supreme Court on a cannabis case years ago, live
Well,
stream, but I've never seen it in Illinois.
and you know, we've watched the Supreme Court on the show
Mm-hmm.
before because like the Illinois Supreme Court, but I was just kind of thinking like I don't know, like appellate courts and stuff like
Yeah.
that. Like,
Yeah.
and I don't even know. Like, if you asked me, like, Cole, what is an appellate court? I'd be like, I don't know. I just hear people say it. But I'm
I'm gonna
starting to
have you come
learn.
with us to court when we go so you can see how it all works. But yeah, we wouldn't get to an appellate court until we finish at the like district level court, if you will, at the so
Gotcha.
it you got like one level that's just your first level, then you've got your second level, which is appellate, and then you've got another appellate level on top of that. That's your
Gotcha.
Illinois Supreme Court. Yeah, so we would only get to those appeals if either we lost and appealed the decision, or if the IDOA loses. Like if the IDOA loses, I would suspect that they would appeal it to the
Yeah.
next court, and then it would get more interesting from there.
Yeah. I'm like disappointed in myself because I know I was taught this in seventh and eighth grade and like I had to know it to pass a quiz and I did know it at a certain point. So
there's
that
no
means I can learn
reason
it again, right?
there's no reason for you to yeah there's no reason for you to know all this stuff anyway, but
No, but it's interesting to know, like, because you know, you sometimes you see the different stories in the news, and it like, what does that even mean? Like, for
right.
example, things with like rescheduling and stuff. Like, oh,
Hmm.
there's a ALJ hearing, you know, and
You're like,
everybody like
what's an
throw
ALJ?
and but not only that, but you know, people just start throwing it around so often that everybody's just like, yeah, an ALJ hearing, and like we're like saying things we don't even know what we're
I
talking
know
about
that the
type of thing.
acronyms do get totally out of control, don't they?
Yeah, yeah. So
Yeah. Well, I'm glad to, anytime you have, legal questions about anything, I'm always glad to jump in and give you my opinion or try to break it down into layman's terms where it's easier to understand.
yeah, I'll remember that because occasionally we do little round tables with you know different lawyers around the state on
Mhm.
certain cannabis specific topics, and um,
It's
yeah, I'll definitely
complicated.
keep that
I
in
mean, I
mind.
get I get twisted up in all of it
But
too,
isn't it fun too?
It is.
And I
That's
think
why
that's
we
what you
do
were
it.
saying earlier
Yeah.
that yeah, I mean it's not always fun. Like let's not paint with a broad brush, right? It can be
Yeah.
pretty grueling and insane. But
Yes.
it's a nice for some reason like you said earlier, you know, you've practiced in different areas of the law and it's not that you don't love you know, don't mean to speak for you, but it's not that you don't love the law. That's obviously why you do it. But when you can mix the law with another
Mhm.
subject that like I say, it's almost the way I pitch it to legislators is like they actually, even if they're anti-cannabis, they enjoy talking about cannabis
Yes,
rather than like mundane topics like
right.
utilities and
Yes.
like shit like that. Like,
Energy. Yes.
yeah, yeah, it's like it's
Yeah.
kind of fun, even if you disagree with the
Yeah.
policy. So
Yeah, being in cannabis, I sometimes think is like a blessing and a curse because if you go to like dinner with people and they ask you about it and they're really curious, you can, like you can really end up going down deep down rabbit holes. Like sometimes you want to, I don't know if you ever feel this way when somebody's like, what do you do? And you want to be like, health and wellness or something,
right.
just so I don't have to answer like 7 million questions about cannabis, you know?
No, yeah, no, I know exactly what you're saying. Sometimes it's like don't even get me started because
Right. Or I get so animated and they're like, Jesus, I just asked her a simple question and she's like
yeah.
going off about like hemp and, or
Just because
whatever.
we can relate, yeah, it sounds like we've both had the experience where somebody like asks you a question to be nice, like, "Oh, you're interested in cannabis," and you're like, and it's like 15 minutes later, and they're like looking at you like, "You wrap it up," and you're like, "Oh
Yeah,
shoot,
I
I
know.
thought
I've been talking for 50, right.
I
I thought
thought
I was
you were,
interesting.
yeah, exactly. I thought you were as interested in this as I am. My apologies."
I know. It turns out nobody's as interested in cannabis as the people who are actually in cannabis,
Right,
you know,
right. We're obsessed with it almost to an
obsessed with
unhealthy
it.
level.
I
So,
know.
well, hey, any bases that we haven't covered with this case, that
Not really. I mean, I think,
the one
I
case
think,
you
yeah.
go ahead,
No,
sorry.
no, go ahead. Go ahead. The Pterodon case, is that what you're going to ask
Yeah, I was
about?
gonna ask about that because is that the one where there were like pictures
Yes.
online? Okay, gotcha. I just wanted to
Yeah.
make sure I was thinking of the
Yeah.
right
They
one.
attached it as exhibits, like pictures of vehicles that the plaintiffs claimed were not properly outfitted or were not the vehicles that they had put in their exhibits or were not being done in the way that they had said they were going to do it in their exhibits. Um,
That reminds me of a different question that's totally unrelated to everything we've been talking about, but like and I don't see this as an angle of based on what you've published so far and what we've talked about so far, but like there was a report that I can send you, and I mean, we don't need to take that. I'll send it to you, and I'll try to paste it
mhm,
in the show notes. But it is a report where basically some MCCs are saying, that they're pointing out how stringent the cannabis transportation regulations are, and then they have like a DEA consultant come on the show, and
mm,
they're like, so what would the requirement be for transporting opioids, for example? And he
mhm,
was like, they were like, could you hypothetically do it on a bicycle? And he was like, I mean, the standard of which we do this is as long as you can safely get it from point A to point B. Yes. So
wow,
hypothetically, yes. And
wow,
well, and I think that's what was an interesting part of the story is that one of the employees of an MCC was saying that they used to transport pharmaceuticals and they
mm,
would just throw them in the front seat of their car, and actually we've had people on the show in the past. I'll just wrap this up, but it's just kind of and kind of ask my question finally. I just wanted to give you a few different examples. A person on my show was from Oregon, and the way that they do it there is like you literally go and buy it and put it in your car and then like take it to the dispensary yourself.
that's
There's
what I
no,
did
oh,
when I was
really?
in New Mexico.
Wow.
Running my business, I would put it in the car and I would drive it. And I would drive
Wow.
it. Yeah, and there was nothing. It was nothing. It was
Yeah.
there
Did
weren't
you have
any
like a
real.
paperwork or something? Like just in
Well, we
case?
had our manifests, yeah. So
Okay.
I would have a
Gotcha.
manifest in the car with me. So if I got pulled over, I could show them what I was transporting. But yeah, no other regulations really to speak of.
Yeah. The person we talked to carried a gun. Did you carry a gun?
I did not, but
She did it
sometimes I
just by
felt like I
choice. Yeah.
needed one.
Well,
Yeah.
that's why
Well,
yeah.
it's dangerous. And I mean, I've often thought like not that the senators like with safe banking would care about what I have to say over anybody else, but it is a real safety issue. Like I would drive around, I don't live in New Mexico. I would be driving around in a rental car with weed and money, right? Because people are paying me. I'm collecting cash and checks and whatever else. And, Albuquerque is one of the most dangerous cities in the world. So I often felt like a sitting duck. And I could understand why someone would have a gun.
Yeah. And I would agree with you that there are some dangers, but the point that I was actually going to make is that And again, I don't see this as part of your case. You didn't mention this at all. So it's honestly just like a hypothetical question, I guess. I don't think that's the right way of wording it, but I'll just spit out the question. The regulations are obviously cumbersome. Even the
Yes,
MCCs agree.
yes.
Is there any point in which you might sue them for that? Like literally, like, and I don't know, like, that was the wrong way of asking that question, but
I know
like,
what you mean.
ask for the damages for that because it's
Yeah,
like,
is there a claim around that?
right, because it's ridiculous.
Yeah, not really.
No.
Um, I mean, not one that I can think of anyway, unless it's a situation like what we have here where they are enforcing the regulations differently, which
Fair.
is which is what the transporters were saying in that initial Greenspoon case. They were saying that these guys are able to transport however they want and nobody the IDOA is not doing anything about it, but we're held to like all these crazy standards and can't even get up and running.
Mm,
So that I think, but I do think that there is a, probably a perception, I guess, that, well, there could be a perception, I suppose, that the IDOA is like anti-business, even that they just are more concerned with the regulations, not anti-business, but maybe when they're balancing like the regulations and the compliance issue with people, having viable businesses and getting up and running, they are weighing the compliance and the regulatory piece far heavier than the business piece.
yeah. Yeah, and
And,
I
you know,
I know their response too is something to the effect of, "Well, this is a Schedule 1 drug," like to all the things that I just said. But again, the opioid thing was an interesting example where it's like that's a pretty highly scheduled drug as well.
that is eye-opening. Well,
And
and I think to your point, like, you know, cannabis companies in general, whether you're an MSO or a small craft grow, have faced insane obstacles over time, you
mhm,
know? Um, and regulatory burden, whether it's in cannabis or in other industries, is always, there's always like a tipping point where people start to say, you're regulating us out of business. I mean, it's a little bit like what Trump is going to allegedly do, which is strip away a lot of regulations and make it easier for businesses to operate, or at least that's what he says. So there's the balance, there's a healthy balance. And I don't know if we've found it here. And maybe there's worse jurisdictions too than us. Um, But, if you go the whole opposite direction, like to New Mexico, where there's like nothing, and I mean, I don't mean nothing, I mean facetiously, but comparatively to Illinois, their market isn't anything that anybody was jumping up and down about, from a business perspective. Whereas here, people want to come into our market because, as far as cannabis goes, this is one of the markets where if you do really well, you can actually make a living.
yeah, like you say,
Um,
from a business perspective, this is the most
yeah,
appetizing.
well,
Uh,
it's appetite, yeah, but it's weird because it's like from the business perspective, all these people want the big guns want to come in because we're limited, but at the same time, we do have really hardcore regulations, right? Um,
True.
that in some instances are really keeping people from having a business.
Yeah. Well said.
So it's tricky.
Well
But
said.
I grew up here in this market. I'm an MSO baby myself, so I feel like I see, and having worked in this market and then New Mexico, which is a 180-degree difference, I feel like I have a really good lay of the land, in terms of everybody, just the difficulties that everybody goes through in this industry. It's just that the big guns have advocacy and money to help themselves, and people like the independent transporters don't.
Yeah.
So,
Well, I was going to give you the closing word, but it seems like you may have just done it. Do you want to say anything else before we go, or
no, I'm just really glad that I get to do this and, like I said, help people that haven't really had much of a voice, and doing it with my own industry is really fulfilling.
cheers to that? Cheers
Yeah.
to that. Well, folks, I hope you found as much value as in this conversation as I did. There are links in the show notes, including to the Chicago Sun-Times story, the disparity study, which we mentioned, and
And the
possibly.
complaint is live online. If anybody, you can actually Google it, and I think it might be linked in the Chicago Sun Times article,
Okay, cool.
along with exhibits.
Yeah, if I see that in there, folks, I'll try to paste that in the show notes as well. Again, hope you found value in this episode, and we'll see you on the next one. Take
Thanks
care.
for having me, Cole. Bye, everybody.